Testamentary capacity is the legal definition of what is required for a person to make a valid will. Testamentary capacity is important because a person making a will must have a certain understanding and cognitive health in order to be able to create a valid will. It's a safeguard for both the person making the will and the people who benefit from the will to ensure that that is done properly. There are a variety of medical conditions that could affect testamentary capacity, but some of the obvious ones are things such as dementia, Alzheimer's. There are various neurological disorders that can be caused by events such as strokes or serious accidents. There are also conditions such as schizophrenia or bipolar disorders that can affect judgment, which in turn has an impact on capacity. And then obviously what we see a lot of is cognitive decline, which can again affect testamentary capacity. The 4-part test is set down in the long-standing legal authority of Banks v Goodfellow. That 4-part test dictates that the testator must understand the effect of what they are doing by executing that will. They must understand the extent of the property they are disposing of via that will. They must also understand the nature and extent of any claims to their estate under that will. And they must also not be suffering from any perverse disorder of the mind. That essentially, in summary, is the 4-part test under Banks v Goodfellow. What it isn't is a memory test, which often gets confused. You can have poor memory and still have the requisite testamentary capacity. The evidence usually needed to demonstrate that somebody doesn't have testamentary capacity will normally involve, firstly, if the will is professionally drawn, a copy of the will file, which is often accompanied by answers to specific questions that have been put to the person who drafted that will. Secondly, you would look to medical records, whether they be GP records, hospital records, care records, and so on. Thirdly, you then look to those around the person that has passed away. So witness evidence from people who can account for their behaviour around the time. Sometimes you will find that there are capacity reports that are either prepared at the time of the will, before or after, and if those are available, then they're of course relevant. And generally you're also looking for any other documentation such as emails, correspondence, messages and so on that might give some kind of window into that person's capacity and mental health at the time that they prepared the will.